Good afternoon, everyone. Welcome to our HHQ webinar. We are glad to have many esteemed attendees with us today for our webinar on corporate rescue mechanism for companies in distress. Before we kickstart this session, please be informed that all participants will be muted, and if there are any questions, please type in the chat box and we will discuss them during the Q&A session later. Please allow me to introduce our speaker, Mr. Lam Man Chan. He is a partner of Dispute Resolution Department in Halim Hong and Quek. Manchan's practice mainly revolves around corporate litigation and critical matters, such as liquidation and restructuring, debt recovery, insolvency, and employment disputes. Over the years, Manchan has acquired vast knowledge and experience in these areas of practice and has advised and represented various prominent institutional and individual clients, both foreign and local, in all levels of Malaysian courts. For non-contentious matters, Manchan regularly provides consultation and related legal services to SMEs from various sectors, amongst others being retail, property development and management, logistics, mining, and agriculture. So, please join me to welcome our speaker, Mr. Lam Man Chan.
In 2020, the soft economic condition in Malaysia is compounded by the COVID-19 pandemic. The movement control order has restricted business operations and caused shrinkage in market demand. As a result, many companies are financially dire and in need of measures to assist them through this unprecedented crisis. Under the Companies Act 2016, there are two corporate rescue mechanisms available to distressed companies, namely corporate voluntary arrangement and judicial management, which come into force on 1st of March 2018, with very clear objective to facilitate financially distressed companies and rehabilitate business viabilities which provide alternatives to liquidation. Besides the two methods mentioned just now, the scheme of arrangement under Section 366 of the Companies Act is also commonly used by companies to restructure debt with their creditors. So the webinar today will touch on all these three restructuring methods. Each of these corporate rescue mechanisms has its unique feature in terms of availability, length of moratorium, level of autonomy, and etc. Therefore, the webinar today is to give the audience an overview on the corporate rescue mechanism to help the companies consider the options best suited for them in the event that such a scheme is needed to rescue their businesses. Okay, corporate rescue arrangement, short-term called CVA, is a self-rescue mechanism initiated by a company to reach an agreement with its creditors for the purpose of compromising on the company's debt. The key feature of CVA is that the company needs to work with a nominee on the implementation of the proposed arrangement. But it is important to know that not all companies are eligible to CVA. So here we have noted out three categories of companies which are not eligible. First, a public company cannot rely on CVA. Second, a company regulated by Central Bank of Malaysia and subjected to Capital Markets and Services Act 2017, they are also not applicable. And last but not least, a very important point, a company which has created charges over its property or undertaking is they also cannot rely on CVA. In short, CVA is applicable only to private companies which have no secured debt, meaning not having any loans from financial institutions. Moving forward, we look at who can initiate CVA. So there are three categories who can initiate CVA, namely the directors, judicial manager, or liquidator. For director, it can be initiated by directors of company in the event that it's not being wound up under judicial management, where a CVA can also be proposed by liquidator or judicial management in cases where the company has been wound up or has been placed under judicial management. Third point, we look at the control of the company. So under CVA, a director remains in control of the company, but under supervision of the nominee. Notably here, the nominee must be an insolvency practitioner who is an approved liquidator as defined under the Companies Act, and he would be responsible for supervising the implementation of the proposal. Okay, four, we look at does CVA require court's approval? No, but the company must file the document stipulated under Section 398 under the Companies Act to be entitled to the automatic moratorium. Next, we should look at the period of moratorium. Under the Companies Act, the company will be eligible for automatic moratorium of 28 days upon filing of the Section 398 documents, which contain, among others, the terms of proposed arrangement, the company's statement of affairs, and a statement by the nominee. It can also be extended up to 16 days, subject to the following approval at the creditors' meeting, with the consent of the nominee and shareholders, and also at least 75% majority in value of creditors who are present and voting. 7, we should look at the effect of moratorium. Upon filing of the Section 398 documents, no petition may be presented for winding up of the company. No meetings of the company may be called except with consent of the nominee or leave of court. No resolution may be passed or order may be made for winding up of the company. No application for judicial management may be made against the company. No judicial manager may be appointed for the company. And also with leave of court, no re-entry or forfeiture may be exercised by landlord for any rent payable. No steps may be taken to impose security over the company's property or to repossess goods under any hire purchase agreement. No other proceedings, execution, or distress may be commenced or continued. And last but not least, no transfer of share or alteration of status of the members can be allowed, except with the leave of court. Next, we should look at the general procedure of the CBA application. First, the director shall appoint the nominee and submit the particulars for the nominee to assess whether the requirements under Section 397 sub 2 can be fulfilled. There are 3 requirements. First, whether the proposal has reasonable prospect of being approved and implemented. 2, whether the company is likely to have sufficient funds to carry on business during moratorium. And thirdly, whether the meetings of the company and its creditors should be summoned to consider the proposal. Upon satisfaction of the 3 requirements there, the Section 398 documents shall be filed in court and the nominee shall summon meetings of shareholders and creditors. Next, the approval of the proposed arrangement requires, number 1, a simple majority of the shareholders, and number 2, at least 75% majority in value of creditors who are present and voting. Once the proposal is approved, it takes effect and is binding on all creditors, whereas the nominee shall be the supervisor for its implementation. Here I will summarize the key features of a CVA. So number 1 is the availability of the moratorium. The protection under the moratorium will allow the company to channel their limited resources into keeping the business operation afloat while the proposal is being approved, rather than spending further costs to defend litigation. Number 2, CVA is simple and also cost-effective. The company will only incur minimum legal costs as CVA does not require cost approval, aside than the mere filing of the Section 398 documents for the moratorium to take effect. Number 3, CVA is management-driven with the assistance of the nominee. The management of the company shall remain with the director, while the nominee only provides an opinion on the viability of the proposal and also play a supervisory role on the implementation of the approved proposal. Next, we shall proceed to judicial management. Judicial management is a cost-supervised corporate rescue mechanism for a company that is financially dire but has prospect to be rehabilitated. On application of the director or creditors of the company and upon approval by the court, a judicial manager would be appointed to manage the company's affair with a view to rehabilitate or to achieve more advantageous realization of the asset rather than resulting to a winding up. But it is not available to all companies. Under the Companies Act, 2 types of companies not eligible to judicial management, which are the companies regulated by Central Bank of Malaysia and subject to the Capital Market and Services Act. From the Act, it appears that a public listed company and financial institution are not eligible for judicial management. As to who can initiate a judicial management application, of course, the director of the company that can, and also the creditor of a company. Next, we will look into the control of the company upon this judicial management application. The judicial manager will assume control of the company once the judicial management application is allowed by the court. Does judicial management application require court's approval? The answer is yes, but subject to fulfillment of requirements under Section 405. Which are the court must be satisfied that the company is or will be unable to pay its debt, and the court shall consider that the JM order would achieve any one of the following purposes, namely, first, the survival of the company as going concern, the likelihood of scheme of arrangement under Section 366, and third one, a more advantageous realization of the company's asset conferring to a winding up. Next, we look at the moratorium. The key feature of it is that the company will be eligible for automatic but limited moratorium upon filing of the judicial management application. Upon approval by the court, a judicial management order shall be valid for 6 months and a full moratorium shall take effect. And can the moratorium be extended? Yes, for another 6 months on application by the judicial management, and also, of course, subject to the approval by the court. And the effect of the moratorium is similar to CVA, wherein there are certain things that cannot be done. Okay, namely, no resolution shall be passed or order may be made for the winding up of the company. Second, no receiver or receiver and manager shall be appointed for the company. Except with the consent of the judicial manager or leave of court, no other legal proceedings, execution of distress may be commenced or continued against the company. No steps may be taken to impose security over the company's property or to repossess goods under any hire purchase agreement. And last but not least, except with leave of court, no transfer of share or alteration of the status of the members is allowed. Next, we should look at the general procedure. On the application of the director of the company or its creditor, the court shall consider the requirements under Section 405, which I already mentioned just now, on whether a judicial management order should be made. In the event that the judicial management application is allowed, a judicial manager shall be appointed and assume the powers of the director pursuant to Section 414. Further, any receiver and manager shall vacate office and application to wind up the company shall be dismissed. Upon making of the judicial management order, the judicial manager is required to present to the members and creditors of the company a statement of proposal within 60 days or such longer period as the court may allow from the making of the judicial management order. Thereafter, the statement of proposal shall be voted upon by the creditors, and a minimum 75% of the total value of creditors present and voting is required to have the statement of proposal approved. The statement of proposal, if approved, binds the rest of the creditors whether or not they have voted in favor of the proposal. Next, we look at the key feature of judicial management is that it has a longer moratorium comparing to CVA. A 6 months moratorium is applicable, possibly a further 6 months upon approval of the court, gives the company ample time to complete restructuring exercise of larger scale and more complex. Next, and the role of an independent judicial manager is also important because the appointment of an independent and professional judicial manager to steer the restructuring process may be more appealing to creditors who believe that the company can be rescued but lacks confidence in the director's ability or willingness to do so. After all, the director's poor management is often the root cause of the company's financial predicament. Next, we shall share with you some recent development in judicial management application. One of the very important and recent case is the case of Biaxis Sdn Bhd, whereby the High Court has set a seemingly high benchmark to meet in obtaining the judicial management order. The Learned Judicial Commissioner has set up additional procedures that is to require the nominated judicial manager to affirm either an affidavit in support or to at least produce an expert report to be appended in the applicant's affidavit. The nominated judicial manager is required to produce a draft statement of proposal as close as possible to the final form, even at this preliminary stage, where there is no certainty that the judicial management or his appointment. Generally, the key takeaway in the cases are that the reliance on the nominated judicial management manager. Traditionally, the application for judicial management is supported only by a general consent to act by the nominated judicial manager and his CV, coupled with at most some general statement on the proposal. The mobilization of the nominated judicial manager is minimal at this stage of filing for judicial management. However, the Learned JC has placed increased reliance on the nominated judicial manager in holding the applicant would not have been able to come up with the proposal on its own, and neither can they consider whether the objective of a judicial management order could be achieved on its own without consulting an insolvency practitioner from the very outset. More often than not, the insolvency practitioner who has provided such consultation will be the judicial manager nominated by the applicant. The court, and also the court in considering the judicial management application, would similarly have to rely on the expertise of the nominated judicial manager. Therefore, the nominated judicial manager should affirm an affidavit in support of the judicial management application because he is the mastermind behind the proposal and will be the key person throughout the judicial management process. He also has the expertise to consider the proposal and is in a position to give an objective view, being a professional without any vested interest. Second point, the judicial management application is to be evaluated on case-to-case basis. The court was mindful that the quality and also the quantity of the evidence to be expected from the applicant and the nominated judicial manager should vary from case-to-case basis. It will also depend who is the applicant is. For instance, more will be expected where the applicant is the company itself compared to a creditor applicant, since the creditor would have limited access to the information of the company. Third, we will move on to the court's expectation of the applicant and or the nominated judicial manager. In essence, the court expects that the applicant and or the nominated judicial manager should demonstrate the application and proposal is bona fide. Second, demonstrate that they have used their best effort to gather and verify all relevant documents, especially the financial information, to get the proposal as close as possible to its final form and to secure the commitment of parties who are injecting money and identifying any outstanding issues. And they must also explain the rationale of the proposal and how it will achieve the goal within the given time frame. Last but not least, they shall make full and frank disclosure of any material risk to the creditors ending up in a less advantageous position. All previous judicial management applications and their outcomes and any other relevant matters should also be disclosed. In setting out the above guidelines, the court has also considered the following factors. Number one, that under judicial management, there is an automatic moratorium, and actually there is a real risk of mala fide applications to take advantage of the automatic moratorium. Secondly, an unsecured creditor are prohibited from opposing the application. And with only 60 days to put the final proposal to the creditors, the proposal on application is expected to be an advanced stage. Next, the proposal put to the creditors should essentially be the same as that assessed by the court. And when the creditors are resting on the assurance that the court has assessed the veracity of the proposal and consider that it is likely to achieve the objective of judicial management. In applying the aforesaid guidelines, the court actually dismisses the judicial management application. Next, we will share with you the case of Gold Coast Mori International Resort, whereby the High Court has recently delivered an important decision that a judicial management order is automatically discharged upon its expiry unless extended by the court. Following the expiry of a judicial management order, a judicial manager loses his power to act for the company. Therefore, any application to extend the judicial management order must be made at least 60 days before its expiry pursuant to the Corporate Rescue Mechanism Companies Rule 2018. Next, we should look into the scheme of arrangement. Scheme of arrangement are not exclusively extended for insolvent companies, but is more commonly used by insolvent companies for purposes of restructuring while receiving the benefit of court-supervised restraining orders, restricting various forms of recovery and enforcement actions against the company. Now, first we talk about the eligibility to the scheme of arrangement. Under the scheme of arrangement, all companies are eligible to apply for scheme of arrangement. And as to who can initiate scheme of arrangement, basically any parties, including the directors, creditors, shareholders, liquidator, or judicial manager, all of them can initiate the scheme of arrangement application. Next, we look at the control of the company. Upon application of the scheme of arrangement, the director remain in control of the company. And next question question, does scheme of arrangement requires court approval? Yes. The scheme of arrangement, even if approved by the creditors in the creditors meeting, needs to be sanctioned by the court to take effect. Is there any moratorium under scheme of arrangement? Yes, but it is not automatic. The application, as the case may be, must apply for restraining order pursuant to section 368, and the court may grant a restraining order of not more than 3 months. Next question, we look at whether the restraining order can be extended. Yes, the restraining order may be extended for a further 9 months if the court is satisfied that there's a proposal for a scheme of arrangement of compromise between the company and its creditors or any class of creditors representing at least 1/2 in value of all the creditors. Secondly, the restraining order is necessary to enable the company and its creditors to formalize the scheme of compromise of arrangement. Thirdly, a statement of particulars as to the affairs of the company made up to date not more than 3 days before the application is lodged together with the application. Last but not least, the court approves the person nominated by a majority of the creditors in the application by the company under subsection 1 to act as a director, or if that person is not already a director, appoints that person to act as a director, notwithstanding the provision of the Act or Constitution of the company. Next, we look at the effect of the moratorium. In a very general statement, all further legal proceedings in any action against the company is restrained except with leave of court. So this is a very powerful and also generic protection. Next, we should look at the general procedure. First, the court may order a meeting to be summoned among the creditors to consider a proposed SOI upon application of the parties mentioned just now. Okay, at the creditors meeting, approval of the scheme of arrangement requires at least 75% majority in value of creditors or members who are present and voting. Once approved, the approved scheme of arrangement needs to be sanctioned by the court with or without modification in order to take effect and shall be binding on all the creditors or members. Now we look at the key feature of a scheme of arrangement. As obviously the scheme of arrangement, it has wider application as it has no limitation on types of companies. All companies can apply scheme of arrangement. Secondly, the restructuring exercise can be extended to shareholders, such as reduction of share capital or even a takeover exercise. Further, it also has lesser restriction, meaning it is applicable even to company with charge. As a conclusion, we actually listed down 5 points to consider, which options to go. Okay, to summarize, there are 5 key areas to look at when the company is considering the options. For example, so the 5 options are the applicability, the complexity, control, moratorium, and also cost. Okay, for example, CVA is only applicable to private companies without a secure creditors. Such limitation placed by the statute against the companies with charges means that many companies are technically precluded from considering CVA, as many companies tend to create charges over their assets. They can only consider either judicial management or scheme of arrangement. Notably, secured creditors could also veto a judicial management application, even though the court can override such veto if it is satisfied that the making of a judicial management is in the interest of the public, but this is not very common. Next, the complexity of the intended restructuring plan is also to be considered. For example, if the restructuring plan involves share capital reduction or takeover by a white knight, one may consider to opt for a scheme arrangement as it can involve the members. Third, all three corporate rescue mechanisms offers different level of autonomy. For instances, judicial management scheme is more invasive as the court, unlike the CVA scheme, where the director remains in control of the company's affairs. All management powers of the company under judicial management are taken away from the company's director and are placed in the hands of the court-appointed judicial manager. However, the director's level of conflict in giving away their management power should also be balanced with the level of confidence of the creditors that the creditors have in respect of the ability of the directors to carry out the rehabilitation exercise. Besides that, the availability of moratorium is also important for the company in distress, as they are often entangled with litigation commenced by their creditors. Therefore, protection from such legal proceeding is very important for the company which requires rehabilitation. Having that said, an automatic moratorium as afforded under the CVA and judicial management may not be necessary depending on how early a company can detect its financial crisis, in which case they may be able to explore restructuring process using scheme of arrangement. Last but not least, of course, the cost factor, as the whole rehabilitation process takes time and involves unpredictability, especially in court processes. And with that, we will conclude our sharing today, and we shall proceed with the next session.
Thank you, Manchan, for the enlightening sharing. I'm sure it is very helpful to many, especially our attendees today. So now we have come to the Q&A session for this webinar. You may post your question in the chat box if you have any question. So I would like to share the questions which has been posted. So again, let me invite Manchan to answer these questions. So the first question is, what is the meaning of an automatic discharge of the judicial management order upon its expiry, and will the judicial manager still be in power?
Okay, under the Companies Act, the judicial management order actually has a validity of 6 months. While it can be extended, okay, in the case that we shared just now, which is the Gold Coast Moray International Resort, Sdn Bhd, in that case, the judicial manager actually applied for an extension of the judicial management order after 6 months. So the issue in dispute is that whether they can do so, whether they can file the application to extend the judicial management order after the expiry of the first 6 months. Okay, of course, the argument taken was that after the 6 months, I mean, the judicial manager basically loses their power to act, and of course, when they loses their power to act, they could not possibly file the application to extend the judicial management order. So the High Court in that case actually decided that yes, indeed, the timeline is to be taken seriously and is to be honored very carefully.
So the next question is, what can a company do if the judicial manager is incompetent to do his job?
Under Section 425 of the Companies Act 2016, the creditors or members can apply to deal with the any unfair prejudice that they suffer. So their relief is under the section.
Okay, so the last question will be, what is the best rescue mechanism that a company can utilize?
Of course, going back to our sharing just now, we actually listed out 5 points to consider, which is the applicability, complexity, control, and moratorium, and also the cost. So this is not a rocket science, and of course, this should be determined on a case-to-case basis. It's a factual question actually. So the 5 key areas after consider, it can basically help a company to decide which methods that suits them best.
So that's all the questions we have for today. Thanks, Manchan. So before we end this session, kindly be informed that an evaluation form will be sent to you via email, and we look forward to your feedback on our webinar today. So I believe that's all the time we have for today. This marks the end of our webinar, and thank you very much for joining us.